For the record, this matter is before the court on the defendant father's objection to a referee recommend order, which denied his motion to modify custody. This hearing is being conducted via Zoom. Appears we have both parties present. Sir, you are Justin Marmorenzi, is that correct?
Sure.
And you are plaintiff mother Laura Gazelle is also present. Good morning,
Correct.
both of you. Good morning,
Good
Ms.
morning.
Flower.
Good morning, Your Honor.
The court has received a recommendation, Mr. Marmorenzi, that you wish to withdraw your objection, which
Yes.
of course would result in the referee recommend order being adopted, namely your motion to modify custody is would be denied. You understand that, sir?
Yes, sir.
Are you aware, and this seems to be appropriate, but are you aware the two of you have joint legal custody and Dad, you have physical custody. So I'm not sure in the court's opinion, this is more of an issue of modifying parenting time, not custody.
Yes.
You've alleged that your son Aiden is doing poorly in school.
Yes.
Well, we need to rectify that. We need to address that. 15 at school is very important.
Yes.
He's actually not doing poorly in school. His current grades are all B's and 1 D.
Mr. Marmorenzi, have you been in touch with Aiden's teachers?
No, I have not, and that is my fault for not doing so.
Absolutely. You should be in touch with the teachers. But at this point in time, you wish to withdraw your motion. Is that correct?
Yeah.
All right. The court will do so. Mr. Marmorenzi, just keep in mind, you have physical custody, and you have joint legal custody. This is more of an issue of parenting time. So if, in fact, I would, of course, suggest talk to his teachers. If you feel that Aiden is still failing in school, you can always file a motion to modify parenting time. For
Okay.
example, one of the thoughts is perhaps maybe you have right now your parenting time during the school years on alternate weekends. Maybe you pick up Aiden from school on Fridays, you take him to school on Mondays, you have him for a longer weekend, or maybe you go week on, week off. If in fact you are available, mom's not helping with homework,
Yes.
and you are more capable of helping them with homework and make sure that homework is done, getting off social media, getting off
When
games.
we were in front of the referee back in November, that is what I had put into place, was a 2 week on, 2 week off joint custody agreement, but it got denied.
Well, no, they recommend denial, but you're withdrawing your objection. Again, obviously, that's sort of a long time to be without their parent, 2 weeks on, 2 weeks off. Maybe, and the two of you as parents know what's best for Aiden, better than any referee. Perhaps two of you should agree, try to do it maybe week on, week off, or maybe Dad, you have with some extended weekends, you're more active and involved with the school. But right now, you're not to keep in touch with the teachers. So yes,
Right.
it is on your part, Mr. Marmorenzi. You need to strongly suggest that you talk with his teachers, get a copy of his obviously semester-ending report card. Presumably that will come out very soon. Is that right?
Correct.
So make sure you receive that. You should be on listed at school for all records and reports, Mr. Marmorenzi. If not, I mean, shame on you. You should have they should have your email address and send you everything, including report cards, progress reports, dates of parent-teacher conferences. If in fact you feel that Aiden is still underperforming or doing poorly in school, you should file a motion to modify parenting time. It's not. This is you already have custody.
Okay.
And maybe the two of you. And Aiden's 15, two of you can reach agreement, maybe week on, week off. Again, I'm not ordering that. I'm just suggesting the two of you to talk about that. 2 weeks on, 2 weeks off is a long period of time being without the other parent. Or the alternative is Dad has longer weekends. I mean, maybe pick him up after school on Friday to take him to school on Monday so you have more time to work with him on your weekends. Just because it's weekend doesn't mean you can't be helping with his homework. So you need to step up, Ms. Marmorenzi.
Yes, sir.
But any event, the court will in fact adopt the referee recommend order, which denies your motion since you're withdrawing your motion this morning. Do either of you have any questions for the court?
No.
No.
All right, so communicate. I mean, obviously, this high school is a significant time in Aiden's life where he's got to be doing well in school to build that foundation for the future. So both of you remain actively involved. And if in fact, maybe try an alter just between the two of you without a court order, try to modify things. So Dad's got a little more time. Maybe Dad spends, Aiden spends maybe Thursday nights at Dad's house so he can help with homework. I don't know what his school schedule is like, but the two of you should be able to talk about that. Dad, of course, claims he can get Aiden to school. That won't be a problem. In any event, the court will adopt the recommendation, withdrawing the objection. So that will conclude this hearing. You can both zoom out. Have the rest of the day. Thank you, Ms. Brower.
You're welcome, Your Honor.
The record, this matter is before the court for continued hearing on the plaintiff's motion for modification of custody, parenting time, and child support. This hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec, representing the plaintiff, Father Cyrus Sarash. Mr. Sarash is present. In addition, Mother Amber O'Connell is present. Good morning, everyone. Happy New Year.
Good morning, Your Honor. Happy New Year.
Ms. Andrus, good morning.
Good morning, Your Honor.
The matter was adjourned from November 28th so that Ms. O'Connell could confer with an attorney. Presume she's had that opportunity, but she's appeared in pro per this morning. The court has received the following recommendation from Ms. Anderson in front of the court. Is that with respect to child support, commencing November 1st, 2023, Ms. O'Connell shall pay child support to the plaintiff father in the amount of $436 per month. Uninsured medical expenses shall be shared as followed. Plaintiff father paying 51%, mother paying 49%. It's based on the number of overnights. Further, it's recommended that the front of the court, I guess it's actually the court, perhaps we should modify that, Ms. Anderson, the court shall, your recommendation is that the court shall adopt the front of the court, shall adopt the Lucas County temporary emergency order dated March 13th, 2023 and November 6th, 2023, and so further order of the court. Do we have a copy of that order? Ms. Andrus, does your office have a copy of that order?
I do not have a copy, Your Honor.
Again, we should, the court needs to attach a copy because I have no idea what that order says. So we need to spell out the terms of this, whatever that is, because if the court has a future hearing, I have no idea what the separate orders say. So I'm going to spell out in this recommendation exactly what the custody and parenting time arrangement is, Ms. Nemec.
I can put that on the record, but it is the March 13th, 2023 order is attached as Exhibit G to my motion. The November 6th order obviously came after filing of this motion, which occurred in October, and we can provide the court with copy, or we can just modify this recommendation to state that that Mr. Sorosh will have primary physical custody. Ms. O'Connell would have parenting time. Give me one moment.
Well, perhaps we should spell that out in this order, unless you're going to prepare a detailed order, Ms. Nemec.
I can do that as well.
All right. So just for the court's information, you're indicating that this Lucas County order,
The Lucas County order, yes, physical custody, primary physical custody was granted to Mr. Sorosh. And what Lucas County did was reverse the parenting time in Monroe County's orders. So Mr. Sorosh's parenting time became Ms. O'Connell's, and Ms. O'Connell's became Mr. Sorosh's.
Okay, so what is that parenting time? Every Tuesday overnight and alternate weekends?
I believe that's accurate. Is that accurate, Cyrus?
Yes. Yeah, and then the summer schedule was every other week. And then we also implement the Monroe County front of the court holiday schedule, and we've flipped that as well as part of it.
In addition, the November 6th Lucas County order required that any of Ms. O'Connell's parenting time, not her live-in love interest, Mr. Reynolds, would not be allowed unsupervised contact with the party's minor child during her parenting time.
Okay. So if the court adopts this recommendation this morning, Ms. Nemec, you'll prepare a more detailed order. Is that correct?
Yes, I can do that.
Right. That will work. All right. So the recommendation that the court shall adopt the Lucas County temporary order dated March 13th, 2023, as well as November 6th, 2023, which, as I understand, grants dad primary physical custody and mom parenting time of the 14-year-old Aurora. Mom parenting time will be every Tuesday overnight and alternate weekends. Philip Reynolds would not be left alone unsupervised with the minor child during mother's parenting time. Parties shall communicate via app close. Father should be allowed to claim the minor child as a dependent for tax purposes for 2023. And further, the parties will mediate with Mr. Pratt on February 29th, 2024 at 8:30 a.m. and subsequently appear before the court for a review. That's the recommendation. Ms. Nemec, this recommendation agree with your client this morning.
It is, Your Honor.
Right. And Ms. O'Connell, do you understand the recommendation?
I do. Is this as a temporary? How does that work when Lucas County closes out in a week or two? How does that work then?
This order of Monroe County will continue until further order of this court.
Okay, so does your court have to do like an investigation then? I'm sorry, I don't understand all of it.
No, there'll be no investigation. Ms. Nimick will prepare a more detailed order which spells out the terms of the Lucas County orders. In other words, they have primary physical possession of the minor child. Your parenting time is every Tuesday overnight, alternate weekends. Philip Braunlich should not be left alone with the child. And so, yes, you need to file a motion to modify that. This, even if the Lucas County case is closed out, this will become an order of this court and will continue until further order of the court.
Okay.
Do you have any questions, Ms. O'Connell?
I have a lot, but I will hold those for when I eventually find counsel.
Okay. Again, did you have any objection to the court adopting this recommendation this morning?
I just don't understand how last time we weren't able to adopt this, but this time we are. I guess I just don't understand the jurisdiction back and forth. Lucas County theirs is very confusing as well. When this is done with Lucas County, they had intended to reverse everything, and then it would go forward with Monroe County then to figure that part out.
This court has primary jurisdiction over Aurora. It's just that apparently this incident, the altercation that occurred in front of Aurora happened in Lucas County, Ohio. That's the reason why Lucas County was involved.
Okay.
So obviously it's appropriate that be, I think once Lucas County knows that Monroe County has entered an order protecting Aurora, that they will then close out their matter. I would assume that. Ms. Nimick, do you believe that to be the case?
I do believe that to be the case. And it is not, for the record, my understanding that any indicated that CPS or Lucas County has voiced to Mr. Sarosh that they intend to, put it back the way it was as soon as they close their case. That is not my understanding of the intent coming out of Lucas County. I believe Lucas County understands that Monroe County has primary jurisdiction over Aurora.
Where does Aurora go to school? Okay, does Mr. Sarosh live in Ohio?
He does not. He lives here in Monroe County. He has been transporting Aurora back and forth to school since he obtained primary physical custody back in March.
Will he continue to do that?
He will, yes.
All right, so if you're going to change the school, it'll be after the current academic year, correct?
Correct.
And obviously it's always difficult on a 14-year-old all of a sudden changing high schools. Mr. Sarosh lives where? In Bedford Township?
That is correct.
All right. Right, so with the understanding, excuse me, do we need to put this in the order, Ms. Nimick? Any objection that the plaintiff shall continue to transport the minor child to high school?
We have no objection to that. That's Mr. Sarosh's intent.
Okay, just maybe put a sentence in there until further order. Ms. Anderson, put this in the recommendation that plaintiff father shall continue to transport the minor child to further order.
Yes, Your Honor.
Of course, opinion that we can certainly revisit that this summer, but we don't want to just pull her out mid-semester. All right, so with that added provision, Ms. Nimick, this recommendation is agreeable with your client. Is that correct?
It is, Your Honor.
All right, so with that added provision, Ms. Nimick, this recommendation is agreeable with your client. Is that correct?
It is, Your Honor.
All right, Ms. O'Connell, again, you have no, do you have any objection to court adopting this?
No, Your Honor.
All right, and you have some questions, but you're going to wait till you talk to an attorney, and in order to change this, you got to file a motion to modify custody or parenting time, and I guess you need to decide who is more important in life. It's Aurora or Mr. Reynolds.
Can it be noted, Your Honor, that this love interest, as this attorney is saying, is my 4-year-old son's father. So it's not just a love interest. It's my son's father.
All right. Well, no child should have to observe any type of physical altercation between adults.
Correct.
So that's obviously a concern of this court going forward. In any event, if there's nothing further, the court will adopt this recommendation. And Ms. Nimick, if you will prepare, we'll note that you're going to prepare a more specific order which incorporates the specifics of the Lucas County orders.
Yes, I will do that. Thank you, Your Honor.
And you submit that under the 7-day rule. Now that's Ms. O'Connell.
I will submit that under the 7-day rule.
So Ms. Nimick's going to prepare a formal order that's going to spell out the terms of Lucas County orders. She can mail that to you along with a notice saying that this will be submitted to the court for entry unless you file a written objection. But only based upon a written objection if there's something that's ordered that is not being addressed today.
That's right.
Understood? Anything further, Ms. Nimick?
I have nothing further.
All right, thank you. Ms. Simpson, you can just simply add a sentence or modify two things. You can just put that the court shall adopt the Lucas County temporary orders, and then have a sentence in there that the child shall continue to be transported to high school, please. All right, that'll
Yes, Your
conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
You're welcome. Morning, after having left the courtroom, pounded on the window outside and told the court to F off. Mr. Merrill. We'll stop by straight. Thank you, Deputy Arndt. Mr. Merrill, the court will not tolerate this conduct. I'm trying to talk to you and explain the deficiencies in this first protection order. Mr. Merrill?
Yes, sir. I choose to stand mute. I have nothing to say.
Are you gonna, did you acknowledge you acted disrespectful and inappropriate?
Do you acknowledge that you just don't give a shit about anything?
Mr. Merrill, I was trying to explain to you the shortcomings. Hold on just a minute.
I know exactly.
Hold on just a minute.
On that paper, I have filled out documents before.
Mr. Merrill, do you want to go to jail for the day?
I stand mute. I'm done. I don't need to talk to you.
Okay, all right. Mr. Merrill, the court will hold you contempt of court for your contemptuous behavior at this court, pounding on the county property in the window. I'll explain to you, Mr. Merrill, and you don't need to respond. You filed a personal protection order against your ex-wife, Melissa Merrill, and also her friend, Max Soul. And your allegation on is that on December 30th, that Mr. Soul came over to your enclosed front porch, was drunk, kicking your door, saying, I quit fucking with Missy, which apparently is your ex-wife. And you called the Rockwood Police Department. There's no allegations that he assaulted you or threatened you with physical harm or violence. What I was trying to explain to you, Mr. Merrill, in order for the court to enter personal protection order, there must be allegations that he has assaulted you or
It
threatened
doesn't
you.
matter. Don't give it to me. I don't fucking care.
Okay, all right. Anything you want to say before the court will find Mr. Merrill contempt of court? I'm trying to explain to Mr. Merrill that you need to either add to your allegations. Based on these allegations, the court cannot enter the personal protection order. If in fact he threatened you or assaulted you, hold your ball. And that's why the court gave you the time of day trying to talk with you.
Okay.
Mr. Merrill, do you want to spend some time in jail? What's going to take you to understand what I'm trying to help you?
You know, I just want these people to leave me the fuck alone. You won't even get rid of my PPO.
I don't know what you're talking about, Mr. Merrill.
You do. I was in front of you before.
Okay, I don't recall. I got dozens of cases. I don't remember each particular case, but I'm trying to explain to you, if in fact the assault you or threatened you, hold their ballgame. You could amend your allegation.
He did. He said Missy sent me here to beat my ass. I did both times.
I'm reading what you. There's no allegation.
I have two witnesses. I asked if they want me to bring my witness statements, and they said no. Just your statement.
You need to act your.
I don't care. I don't want your fucking PPO.
All right, court will hold Mr. Merrill contempt of court. Mr. Merrill, what do you want to say before it makes sense?
Nothing, bitch.
Hey, Mr. Merrill.
Yeah, fuck you guys.
I'm trying to explain. You're trying to help you.
Fuck you. Nazi bitch.
Hey, court already served 30 days in Merrill County Jail.
Yeah, fuck you. Stop fucking get your goddamn hand off me. Stop being a man. Stop.
Thank you. For an adjourned hearing, the plaintiff's motion for ex parte relief, temporarily suspending defendant's parenting time. This hearing is being conducted via Zoom. President is Attorney John Filkins, representing the plaintiff mother, Agatha Christina Mayoris. In addition, Attorney Ms. Mayoris is present. In addition, Karen McDonald is present, representing the defendant, Father Robert Pollock is Mr. Pollock is present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
By way of history, this ex parte order was entered by Judge Lohmeyer in this court's absence. Judge Lohmeyer entered the order on October 13th, suspending the father's parenting time. Security date in this court is back in this court's docket, November 1st, at which time the matter was continued at the request of Mr. Pollock so he could consult an attorney. Thereafter, Mr. Pollock retained Mr. McDonald and counsel. The matter was continued for November 28th, and counsel between the parties agreed to adjourn from November 28th to today's date. Court was obviously reluctant to adjourn something this important so long, but that is the history of this matter. And Ms. McDonald, the court could not find your appearance or response to pleadings. If you could please correct your pleadings, first of all, I'll give you the correct. You got the wrong case number. You got the wrong names. They're all misspelled. First of all, the case number is 13. So you had it.
6-9. I apologize for that, Your Honor.
Correct. So it's erroneous. So the clerk's office could not find a file, and your client's name is Mayoris, not Mayors. Correct.
Thank you, Your Honor.
Mayoris, Mayoros. You spelled it Mayoros.
ORS.
And the defense name is Pollock, Paluch rather than Paugh.
Correct.
So it created a lot of confusion in the clerk's office. And I finally had just read your response to pleading in the last 10 minutes, Ms. McDonald. So please correct your spelling and your
Will do.
pleadings. Right. And also, when this court, what the court's also concerned is Mr. Filkins. When Judge Lohmeyer signed this ex parte, she didn't even have the attachments. I know from the court file, reviewing this court file, that you mailed to the clerk's office on October 17th the exhibits which you neglected to attach to your ex parte order in motion. One of which was a letter from, you said letters that you received by the clerk's office on October 17th. The closed please find attachments which were inadvertently missed when sending the verified motion and order to suspend parenting time. And of course, Judge Lohmeyer entered this order on October 13th, so she didn't have the benefit of any of these attachments. And the court file contains a letter from one of the attachments. It's a letter for Possibilities Counseling LLC dated October 9th, 2023. It's a one-page letter. There's no signature. I don't know how many pages it is, but it's only one page. So your petition, this court never would have entered the order. That's what I'm saying, because it was woefully inadequate. In any event, the court still is not in. There's only one page of this letter. I don't know what it's a whoever Possibilities Counseling is. I don't know if there's 2 pages, 3 pages, 5 pages, 10 pages, but the court file only contains the first page. So the court's not going to put much weight in that. In any event, the parties have conferred with Mr. Walker for the court. Mr. Walker has provided the court with fine recommendation that father shall spending time shall be reinstated every Thursday from 3:30 p.m. to 7:30 p.m. for the next 2 weeks. The father shall start his spending time on January 20th. Thereafter, starting on Saturday, January 20th from 10 a.m. to 7 p.m. The following Sunday, January 28th from 10 a.m. to 7 p.m. Thereafter, its prior parenting time shall be reinstated. Further, that neither party shall discuss any negative issues regarding their significant others in the presence of the minor child. That is the recommendation. Mr. Filkins, is this recommendation agreeable with your client this afternoon?
It is not, Your Honor.
It is. I'm sorry?
It is not, Your Honor.
All right, Ms. McDonald, is this recommendation agreeable with your client?
It is.
All right. One moment. Parenting time of the defendant father was the first and third weekends of the month, as well as every Thursday evening. Is that correct?
Yes.
And that was a May 2014 order. All right, Mr. Filkins, what's the basis for your objection?
Your Honor, the presentation this morning did not include any testimony from any individual. Mr. Walker did not hear from, and she is waiting and prepared to testify from.
This is a motion hearing, Mr. Filkins, not evidentiary hearing. We don't take testimony on motion hearing days.
Understood.
Maybe do in Wayne County or Washtenaw County or Oakland County, but not in Monroe County.
I would advise the court that Michelle DeJulian is present and prepared to give testimony in support of her counseling records. The additional factor here is the issues that were raised in our motion have not been addressed or rectified since the time of the filing of the motion. We've had no information to indicate that they've been rectified, other than the response of pleading submitted just at the end of last week from Father's Counsel. So my client is still concerned for the well-being of the child, mentally, emotionally, etc. And those issues have not been addressed. Father has only had telephonic contact with the child since we were last here in court. And there are new or additional concerns that have been raised, to my understanding, with Ms. DeJulian by the child that we would like the court to be aware of before issuing an order.
Okay, do the allegations suggest that dad's parenting time is a danger to the physical, psychological, emotional well-being of this child? These allegations are pretty broad-based in general. Well, dad's involving her in adult drama situations. I mean, come on. Well, I don't know what that's about, but we need something more specific.
Yes, I would indicate to the court that the child was involved by not only the father in adult conversations with regards to his relationship with his, whatever she is, girlfriend, ex-girlfriend,
Right. Ms. McDonald, do you have the full letter from this Mr. Julian?
I do. It was attached to a copy of the motion that I received from Mr. Filkins. In my response, I question not only the veracity of it, but the origin of some of the allegations. There are some significant allegations in there. One indicates that Mr. Julian was seeing Adriana on a weekly basis. Based on the records that she produced, she saw her about 1.6 times per month. She's evaluated her at school. It appears she might be a holdover from a school social worker, which now Adriana is receiving counseling from. Furthermore, she evaluated her for ADHD. So that it calls into question that the frequency of the treatment. In addition to that, she describes Adriana's concern about my client's inability to earn income. My client is gainfully employed, always been gainfully employed, never filed for bankruptcy, always had a home, a vehicle, and been able to meet his child support obligations and take care of his daughter. I don't know where she would get that notion. Another portion that's very troubling is her recitation of quote unquote my client's criminal activity. My client was charged over 10 years ago when Adriana was a toddler. There's no way she could have any personal knowledge of that information. It appears to me the letter it contains hearsay within hearsay, so it's not just recitation of facts that she was told outside the presence of the court or in an affidavit, but furthermore, it's statements that were repeated by the minor child from another person. In addition to that, there's no verification of those facts, no independent verification of those facts in her letter. And I found it shockingly biased against Mr. Paluk, particularly in light of the fact that she never contacted my client regarding any concerns, never asked to meet with my client regarding any concerns. And these alleged recordings have never been produced. And it doesn't indicate whether or not she has listened to them or if anyone has listened to them, and their authenticity as well as their admissibility is also highly questioned. One thing I do note about Mr. Julian, as well as the allegations in the motion, not one of them is supported by a law enforcement narrative, report, or affidavit. And CPS has not visited my client regarding these allegations. My client has lived with his live-together partner for 11 years. They had a bad day when the minor child was not present. It appears that the other minor child may have tried to involve her in it. I'm not quite sure exactly what happened. I wasn't there. But it's been 90 days since my client had parenting time, and he's seeking to reinstate his parenting time. And with Mr. Walker's help, he agreed to go slowly because it's important that Adriana is comfortable and that they re-enter parenting time carefully.
Does Adriana have her own bedroom in her dad's house?
Yes, she does, complete with a bed, a dresser, and a desk, as well as her personal effects. The house is... I'm sorry, Your Honor, I interrupted you. I didn't
You
mean to.
indicated that Mr. Pollock lived just with his girlfriend. Is there not also another child living in the same home?
There is. She's 14 years old. The girls are about a year apart, and my client and his live together partner have been residing with one another for 11 years. It's a long-term relationship, Your Honor.
So it's a 3-bedroom home. Both of the young girls have their own bedrooms?
To my knowledge, yes, although I would ask Mr. Paluk directly on the record if you wish.
You want me to answer that?
Yes. Does Adriana, does she have her own bedroom, or does she share it with your girlfriend's daughter?
They have their own bedrooms.
Okay, so you got a 3-bedroom home then, correct?
I have a 5-bedroom home.
All right. Then protective services not involved, Mr. Filkins. Obviously, if there's concern about the welfare of this child, protective services, law enforcement be involved. They are sort of vague allegations, sort of hearsay. Perhaps one thing we could do is maybe have a front of the court interview Adriana. The court is reluctant to have the minor child involved by court personnel, but if that's what the parents want, we can do that, and we come back for review, and if necessary, then we'll schedule for an evidentiary hearing. But Mr. Filkins, is there anything that you want to add? Anything, Mr. Filkins?
Just as going back, three issues. The first one was after the court had determined that I did not attach the complete exhibits. The court contacted me, and on October 13th of 2023 at 12:49 p.m., I would have emailed a copy of those attachments to the court. And we would have contacted the court after that to confirm that they had received those documents. So it was my understanding the court has a complete copy of the motion, the affidavit, and as well the letter. But if you're indicating you do not have it, I don't have an explanation, but I'm happy to provide that.
Additional copy of the motion, absolutely. But you say there's also an affidavit?
Yes, there was an affidavit. Well, the motion was signed by my client, so that affidavit. But the letter itself from Possibilities Counseling, that would have been emailed to the court October 13th. I've got a copy of the email here in front of me. That's why I raised that. The second issue is when counsel indicates that the idea here is to take it slowly and ensure the child's best interest, this child is still going to counseling with the therapist. It has still been ongoing since the time of the filing of the motion. And that's why I think it's essential that information be provided to the court. The third and final thing was from the standpoint of the child with regards to what constitutes furniture in the home. My client would have spoken to the child. There was a discussion about father being able to sleep someplace else, and that there wasn't available furniture upon which he could sleep in the home. And that since that time, father has now acquired furniture. That's my understanding. But as far as separate living arrangements, again, these were not things that my client contacted me and said, hey, John, there's a concern with regards to what's in the father's home. These are things coming out from the child directly to the therapist. And I would agree, if this was some short duration, my client in the month of August took the child to the therapist for the very first time, I would say, hey, yeah, this is a short-term issue. But this child has been in counseling, in therapy for on originally a weekly basis since April of 2023. And this is the counselor's not her first contact with this child. So I do think there's significant concerns here. And that's why we object to, in essence, restoring father back to his regular parenting time beginning in February.
But it is highly unusual that this 13-year-old child would all of a sudden disclose to therapist concerns about dad's criminal history that dates back 10 years and express concerns about dad's financial situation. What would prompt those? Highly unusual, but that does not seem to affect the child's physical or emotional well-being. And so at this point in time, the court will adopt the recommendation of Mr. Walker. We're going to start slowly to reestablish dad's parenting time. So dad's parenting time will be every Thursday. We'll start, of course, tomorrow, 3:30 p.m. to 7:30 p.m. for the next 2 weeks. And then Saturday, January 20th from 10 a.m. to 7, and that Sunday, January 20th, and then in February, Dad's parenting time, previous order shall be reinstated. And Mr. Phillips, it would help. I'm going to give you a review date. It would help if we get updated letter from this counselor. This letter is dated October 9th. So maybe something that's updated in terms of December of 2023, if not January 2024.
Understood.
That would be helpful. What's everyone's thoughts about having Mr. Walker? What do you think about having Ms. Scott interview this child? Do you have any thoughts in that regard, Mr. Walker?
If we're going to do a child interview, Your Honor, of course, that's Your Honor's prerogative. I believe we'd probably have to give it about a month, at least, maybe a month and a half to get the child in.
Mr. Filkins and Ms. McDonald, what's your thoughts on having the front of the court interview this 13-year-old child?
I think that would be an excellent idea, Your Honor.
Your Honor, I have significant concerns about that. The letter from the therapist, and I just want to indicate my problem is twofold. One, it appears that the therapist is decidedly biased against Mr. Paluk. And I would indicate for the record that I subpoenaed all of the dates of service from the therapist. The last appointment was December 8th. Prior to that, the last appointment was November 17th. Prior to that, the last appointment was the 27th.
What's your objection to the front of the court interviewing this child?
My objection to actually, I'll withdraw it, Your Honor. No objection.
All right, Mr. Walker, if we can we'll put in your recommendation that the minor child shall be interviewed by Catherine Scott from the front of the court. And then if you could put also, let's come up with a review date. I think Ms. Scott can interview the child sometime later this month.
Yeah, I would give at least until the end of the month.
Okay, so let's look for a review date sometime in maybe second week of February. Mr. Filkins, Ms. McDonald, you available on February 13th at 8:30?
Your Honor, in person or via Zoom?
By Zoom, and if there's any remaining issues at that time, then the court will schedule a quick evidentiary hearing and take testimony.
That's okay with me, You're on February 13th. I just need to know what time.
8:30?
8:30.
Thank you, Your Honor.
Right, via Zoom. So, Mr.
Thank
Walker,
you, Your Honor.
the recommend order that the court will review this matter February 13th, 8:30. In the interim, the minor child will be interviewed by Catherine Scott. The court will provide a written report, and counsel will get a copy of that report. But in the meantime, the court's going to reinstate Dad's parenting time as recommended by Mr. Walker. And Mr. Filkins, would be helpful if you get an updated letter and send that to counsel in the court prior to the February 13th review. That would be extremely helpful.
I have two inquiries, Your Honor, along those lines. The first inquiry is if I'm providing with an updated letter, I'm assuming that the court does not need me to have her present on February 13th at 8:30.
And unfortunately, my motion hearing day, there's motions every 30 minutes. I don't have time to take testimony.
Understood.
So not have time to take testimony that day. And I'll leave it to you whether you want to get an updated letter. It wouldn't hurt. Again, the letter that we've got, everyone's got is dated October. It's now, it's a number of months past. So maybe a short updated letter would be helpful. I'll leave that to you. I'm not going to order it, but I would leave it to you. But we will not, unfortunately, have time to take testimony that day. If we don't come to some agreement on February 13th, the court will then schedule a quick evidentiary hearing in which we can have her present her testimony. We'll do that before the end of February.
Your Honor, the other inquiry I had, and just this is clarification, under the prior order, when father would exercise his visits on Thursdays, those were typically taking place outside of the presence of the girlfriend. And also those were taking place in Trenton, where the child resides, given the short duration of the time. I wanted to know whether or not that is going to continue to be the circumstance. And also with regards to, and since we have Mr. Walker present, I did not know whether or not it was Mr. Walker's intention that the child not be around the girlfriend on these weekend visits. Since they're David.
Maybe I missed some allegations. There's some allegations that the girlfriend is a danger to the minor child.
Not from a danger from a physical standpoint, Your Honor, only from a mental standpoint, mental or emotional.
Yeah.
Your Honor, I would indicate I've seen no proofs as to that regard. I've heard allegations and I've seen hearsay, but I have seen no offer of proof. And my client has lived with his partner for 11 years with no complaints till today.
Your Honor, that was discussed in the breakout room, the issue of whether or not the girlfriend would be present during parenting time. And I believe the intent was, after talking to both sides, that the Thursday parenting time would not be with the girlfriend. However, the weekend parenting time maybe.
All right, does that clarify things then, Mr. Filkins, Ms. McDonald?
It does.
It's reasonable.
It does.
All right, so Mr. Pollock, you should be focused on Thursdays with your daughter. It's dad and daughter time. Maybe you get bite to eat at her favorite restaurant. That would be appropriate. So the Thursday nights will just be you and your daughter, Mr. Pollock. Do you understand that?
Yes, sir. These first couple weekends, correct?
Yes, that's
Yes,
correct.
sir.
But
Yes,
then
sir.
when you have weekend parenting time of January 20th, then yes, that obviously be in your home. So that's a good part of a day, the 20th and the 28th, the Saturday and the following Sunday. So yes, she can be present, but keep in mind, she needs to know her place. She's not mom.
Yes, sir.
So the Thursdays will be just father and daughter. If we need to, Mr. Walker, we can clarify that if we need to, just father and daughter time. And that's what the court suggestion is. Rather than have a girlfriend leave the home, maybe just find out where she likes to eat. You should know at her age what restaurant she likes, whether it's Olive Garden or whatever, and take her out to favorite restaurant. The two of you can have dinner, just the two of you can focus in developing that relationship.
Yes, sir.
So we also had this recommendation that the matter will be reviewed on February 13th at 8:30. We're going to go slow to reinstate dad's parenting time. February 13th, if necessary, we'll schedule an evidentiary hearing, Mr. Filkins. I will assure you of that.
Understood, Your Honor. Thank you.
What do the parties do in terms of exchange? Do they meet somewhere? Does dad pick up when it's his time and mom picks up afterwards?
Father
I'll make sure we're on the same page.
I do all the traveling.
Okay. I'm not sure where mom lives.
She lives in Trenton.
Okay. So, well, again, who picks up?
I do all the picking up and dropping off, sir.
All right. So now I'll continue then. All right. Mr. Falk, you'll continue to pick up and drop off. Okay. So again, this will start then to tomorrow at 8:30. I'm sorry, 3:30 to 7:30. So make sure she gets home at 7:30. What about schoolwork?
I just
Let's say she's off school this week, correct?
Yeah, I just wanted to bring it in, John, excuse me for speaking. I just want to make clear to the court, she does have her cheerleading obligation. So I didn't want to derail from earlier, but I did just want to state that this week she does not have school and her cheerleading will not interfere. Next Thursday, when she's back in school, it will interfere. And previously, he would keep her for the time that she was not at practice and then drop her off at school from there. I just want to confirm that we're good for that, for those Thursday days. That's what we've done in the past and has worked. I don't think it will cut in because it's traditionally 3:30 to 6:30. I think practice is from 6 to 8, if I'm not mistaken.
Right. Mr. Paul, you can make sure you get your daughter cheerleading.
Yes, sir.
Okay. You know where it's at? Is at school and you know the time?
Yeah, the cheerleading usually happens at her school. If it's somewhere else, she can let me know.
Okay, so you'll pick her up at 3:30 then. Again, she has no cheerleading this week. Is that correct, Miss Mayoris? But she will have cheerleading next week.
Her cheerleading this week is from 10 to 12 in the morning, so it will not impact any time.
What about the evening though of January 11th, a week from Thursday?
Yes, it would resume. Yep, next week back to it 6 to 8, 6 to 8:30.
Okay, so I'm gonna pick up at 3:30 and have perhaps an early meal, Mr. Pollock. Is that your intention? And get her to cheerleading by 6 o'clock?
Yes, that's what we usually do.
Okay, all right. So it's important that she continue that same. If you got extracurriculars, you need to make sure you get her there on your time.
Yes, sir.
Same with weekends. When we start the Saturday, January 20th and the 28th of January, if she's got something on that Saturday or Sunday, you need to get her to the after school function.
Yes, sir.
All right. Is there anything further this afternoon, Mr. Filkins or Ms. McDonald?
No, Your Honor. Thank you.
All right.
Thank you.
All right. We'll see everyone back then on February 13th at 8:30, and Ms. Scott will reach out to the parents to schedule that interview of Adriana. Okay, that will conclude this matter. We can zoom out. Have a good rest of the afternoon.
Thank you, you too.
Accordingly, defendant father's objection to a referee recommended order that his parenting time be suspended until he completes a counseling and small program, as well as defendant's motion for to show cause for alleged parenting time, as well as defendant's motion to modify and reduce child support. This hearing is being conducted via Zoom. President Maria Zagorski representing the defendant to petitioner Matthew Hobson. Mr. Hobson is present. In addition, plaintiff mother Ashley Hobson is present. There's a now Ashley Calhoun.
Yes.
The parties have conferred with Ms. Andrus this afternoon for the front of the court. Ms. Andrus has provided the final recommendation that father shall be granted make-up parenting time. Parenting time shall continue as previously ordered. Father's Wednesdays parenting time shall commence today, January 3rd, 2024, and his weekend will begin January 5, 2024. Further, that the issue of child support shall be referred to the front of the court for formal investigation recommendation, with each party have 21 days in which to object. The effective date of any child support ultimately ordered shall be December 1st, 2023. Both parties shall forthwith and promptly, timely turn in their financial questionnaires. Finally, defendant is requesting a finding of contempt on plaintiff and requesting attorney fees. Perhaps we shouldn't need to address this. Make a parenting time. Have the parties agreed on how many days that is?
I don't believe Ms. Calhoun agrees with the recommendation, Your Honor.
Okay. But how many days to make up parent time is the father requesting, Ms. Korsky?
Thank you, Judge. When I look at the calendar and based on the front of the court holiday schedule, it appears to me that Mr. Hobson lost 2 weekends because of Thanksgiving and the Christmas holiday. He lost 6 Wednesday overnights, and he lost 8 days at Christmas. So by my math, that is 18 overnights, 18 days.
18 days or 18 overnights?
No, I'm sorry. It's 20 because his weekends are Friday, Saturday, Sunday overnight. So 2 times 3 is 6, plus 6 plus 8, 20 overnights it would be.
Okay. Miss Andrus, did you go through those weekends and days with Miss Calhoun?
Correct, Your Honor. Miss Calhoun is unwilling to have those make-up parenting times due to she feeling that the minor child's endangered. I believe there was a police report made by Miss Calhoun back on November 8th, and Dad has not had time since. Ms. Zagorski also gave me the police report that was done.
Right, but so in other words, Miss Calhoun agrees that Dad was denied parenting time those same number of days, correct?
I did not look at the calendar to see that, so I'm not exactly sure.
Okay, well, I'm gonna talk with Miss Andrus. I want you to go through because the court's inclined to grant the father make-up parenting time. And Mr. Calhoun, so I want you to make sure that your schedule, rather than me take for the next 20 minutes going through your schedule, I want to talk to Miss Andrus, Ms. Zagorski, so you can go through your calendars to determine what days, right or wrong, when he was denied parenting time. Okay?
Yes.
For the record, this matter is before the court on the petitioner's motion to terminate personal protection order entered on May 15th, 2023. This hearing is being conducted via Zoom.
November 17th, there's a stipulated order for dismissal on November 27th.
Oh, so it's been dismissed, closed.
Yes.
All right. And but the court was inquiring of a divorce action pending between these parties. The court's informed that the divorce action was dismissed in November of 2023. In any event, this PPO termination hearing at the request of the plaintiff was scheduled for hearing today at 2:30 p.m. via Zoom. It's now 2:50. neither party has appeared, the court will currently enter an order denying the motion to terminate. Record this matter is before the court, and then the defendant files a motion for order to show cause, alleging denial of parenting time on the part of the plaintiff mother. This hearing is being conducted via Zoom. Present is attorney Abu Farah representing the defendant, petitioner Victor Solo Jr. Mr. Solo is present. In addition, Megan Osmus is present.
Yes.
Okay, this is Ms. Osmus. Good afternoon, everyone.
Good afternoon, Your Honor. Your Honor.
Parties have before with Ms. Brower. Please provide the court the following recommendation. Is that file shall have parenting time every weekend from Friday at 5 p.m. until Monday at noon. Parties shall meet at the Monroe Police Department for the changes. The holiday schedule shall be followed per the Brownstown Public School calendar. The parties shall communicate via app close. All appointments for the children shall be added to the app close within 1 hour of the appointments being made. Neither party shall cancel any appointments for the children if scheduled by the other parent. Finally, both parties shall complete the SMILE program. That is the recommendation. Ms. Abu Farah, is this recommendation agreed with Mr. Solo?
Yes, Your Honor, it is.
Okay. Ms. Osmus, do you understand the recommendation?
Yes, I do, Your Honor.
Do you have any objection to the court adopting this recommendation?
No, I do not.
Okay. You just can't unilaterally deny parenting time. If you have a concern, you need to file a motion with the court.
I understand, Your Honor. He's been getting plenty of extra time.
Okay. Does Mr. Solo have a license and an automobile?
Oh, absolutely, Your Honor.
Yes,
Okay.
Your Honor, he does.
Okay.
It's Miss Osmus that doesn't have a license or an automobile.
Okay. Court stands corrected. Thank you. So, Ms. Osmus, how are you going to get to Monroe then?
I am capable of getting there every weekend.
Okay.
It's just the Wednesdays that have been an issue. And Mr. Solo has been in agreement with everything about these Wednesdays.
Okay. So anything we're changing then is we're changing everything. There'll be no more Wednesdays and also the weekend parenting time, rather than alternating weekends from Friday after school to Monday school. It's every weekend from Friday at 5 to Monday at noon.
I'm comfortable with that.
Ms. Abu Farah, that's correct. That we're modifying both the weekend and the Wednesday parenting time.
That is correct, Your Honor.
Okay. So it'll start this weekend, correct? This Friday?
I'll still have the children.
Your Honor, we are still in the holiday schedule. The children follow the Brownstown School District, which means Father's Christmas time ends next Sunday, but Sunday into Monday will be his parenting time. So Mom and Dad will exchange Monday at noon.
Okay. Just want to make sure we're on the same page. All right. Ms. Abu Farah, do you wish to voir dire Mr. Solo? He did participate in the discussions. He's in agreement, but do you wish to voir dire him?
Just briefly, Your Honor.
Okay. Please go ahead.
Mr. Solo, have you heard the recommendation that's been put forth on the record by Judge Braunlich?
I have.
And have you voluntarily entered into this agreement?
I have.
Do you agree with the court entering in the recommendation today?
I do.
Do you have any questions or concerns for the court or for myself?
No, I don't.
And do you understand all the terms and the provisions of the new recommendation?
Oh, absolutely, yes.
No further questions, Your Honor.
May I
ask a question?
Yes, Ms.
I
Osmus.
understand that the situation between Mr. Solo and I has been pretty crazy, but I question the need for the parenting classes. I really don't think it would be necessary on my part or his. Just a waste of time, to tell you the truth.
Well, it's not parenting class. It's simply it's an acronym, SMILE, for Start Making It Livable for Everyone. It simply assists the two of you in communicating better. That's all.
Okay, I was thinking it was some kind of thing we both had to go through.
No, Ms. Brower, how do they get instructions? It's an online program, correct?
It is. The front of the court will mail out a copy of the SMILE order with this order that you signed today. The parties shall receive it in about a week.
Perfect, yeah, I would highly recommend it for both of the parties, since there is a lot of friction and continuous arguments between the parties.
All right. Right. So you get instructions about this, Mr. Osmus, and yes, it's simply there's enough challenges in life. Don't make it things more difficult. Your children are very young, 4 and 1. Now is the time to start working together because they get older. They're going to sense when there's animosity and tensions between the parents. So hopefully this will minimize that. So you'll be mailed instructions. Do you have any other questions?
No, I do not.
All right. Thank you. Thank you, Mr. Abafar. The court will adopt the recommendation. Copy mailed out. Now we'll conclude this matter. Everyone can zoom out. Thank you, Ms. Brower.
Thank you so much, Your Honor. Have a great day.
Thank you, Calhoun and Mr. Hobson able to agree upon the number of denied parenting times.
Correct. It came out to 17 overnights. The recommendation was, it's not in your queue yet. It's taking a second, but instead of doing 2 weeks in the summer, they agreed dad gets 4 weeks, and then an extended weekend for the remaining 3 days. That recommendation should be in your queue now, Your Honor.
All right, thank you, Mr. Estes. I do see it. All right, the court's in receipt of the following revised recommendation that father should be granted 4 weeks of make-up parenting time instead of 2 weeks during the summertime. The 4 weeks shall be split into blocks no longer than 2 weeks. So apparently two-week segments, or 2 weeks and 1 week and 1 week, total 4 weeks. Father should give mother the 4 weeks he plans to take in the summer. I'm sorry. Father shall give mother the 4 weeks he plans to take in the summer, an extended weekend to make up for the remaining 3 days by May 1st, 2024. Father's parenting time shall continue as previously ordered. Name is Wednesday shall commence today, January 3rd. The weekends shall begin this weekend, Friday, January 5, 2024. Again, child support should be referred to front of the court for a formal investigation recommendation with each side of 1 day's notice to object. The party shall submit their financial questionnaires. Any modification of support shall be effective December 1st, 2023. Again, the court notes father's requesting a fine of contempt on the part of the plaintiff, requesting attorney fees. The court will also know we do have an objection to a referee recommended order, do we not, Ms. Sikorsky?
Yes.
The recommendation of the referee.
I'm sorry. Yeah, this recommendation from Ms. Andrus addresses that objection because the referee had recommended that my client's parenting time be reserved until he completes 2 counseling sessions, and that was the basis of my recommendation.
Okay, perhaps we need to put in this order that at least we recognize there is an outstanding objection there. So perhaps Mr. Answer even had a sentence at the very bottom of the referee recommended order of December 6th is set aside.
Yes, Your Honor.
Ms. Sikorsky, any objection to that? Just to make it real clear so we don't have some question down the road what happened to the referee recommended order.
No, that makes sense.
It implies that it's set aside, but I'd like to specifically say that the referee recommended order be set aside. That order, of course, suspended, recommended that dad's parenting time be suspended until he completed the SMILE program and 2 counseling sessions with a licensed psychologist.
No, that makes sense.
With these clarifications, and Ms. Sikorsky, your client is asking the court to adopt the recommendation. Is that correct?
Yes. Thank you, Your Honor.
Okay. I just want to make sure it's clear that one because everyone, the parents know, but basically dad shall have 4 weeks in the summer instead of his 2 weeks. So he's given 14 overnight during the summer, correct?
Yes. And then an additional 3 overnight weekend, and he'll give notice to Ms. Calhoun of all of those dates by May 1st.
Okay. All right, Ms. Calhoun, do you understand the recommendation?
Yes, I don't agree with it. I understand it.
Okay, Ms. Calhoun, if you have some issues with parenting time, you need to contact Protective Services or file a motion. You just can't unilaterally decide, I'm just going to deny parenting time. You cannot do that.
No, I did file a motion. I filed a motion back in November. For his time to be reserved due to the fact of he punched Olivia numerous times and then told her he was going to strangle her with a phone cord. There's the police report.
But Ms. Calhoun, until such time as court enters an order, you just can't, just because you filed a motion doesn't mean you can deny parenting time. You need to wait for an order.
Okay.
There's never been an order entered that this court makes the decision that dad's parenting time be denied. If in fact there's concern child be assaulted, contact Protective Services and the law enforcement.
They were contacted, yes.
Okay, is there an open case right now?
It got sent over to the prosecutor. There is a police report. It was approved and sent over to the prosecutor. On when was this? It was reported 11/14 and it was sent over, I believe, the 14th as well
Okay.
of November.
Have you followed up with the prosecutor to inquire if they're going to do anything or if they've closed it?
Well, I did contact them. I never got a call back yet. I left a message with them.
Okay. Ms. Skorsky, do you have any information about this report to law enforcement?
Yes, Your Honor, I got a copy of it. I provided it to Ms. Anders. I'd be happy to provide it to you. The alleged victim stated, and I quote, responding officer inquired to where, and she stated, I'm pretty sure it was in my left leg. It may have been both. I really don't remember. Responding officer inquired if she knew what arm hand Mr. Hobson used to strike her. She stated, I think it was his right. No, I'm pretty sure it was his left. It's absolute garbage, Judge. There aren't going to be any charges authorized. To the best of my knowledge, there haven't been any charges authorized. The prosecutor is not going to be able to prevail in this case based on the witness's testimony. This child reiterated what her mother told her to say.
All right. Any objection to the court putting this in order? There'd be no corporal punishment. In case, I don't know if that was a situation, but any objection?
No
to
objection.
No corporal punishment?
Absolutely. No objection.
Right, so Ms. Callan, we're going to put in this order that we should no corporal punishment. Namely, neither one of you shall physically discipline your daughter.
Well, punching isn't a discipline, and telling her he was going to choke her with a phone cord. And then there's also a recording that Miss Hombridge, she listened to, and that's why she states that he needs 2 counseling and the SMILE program, because Matt verbally abuses him, not just obviously physically, but mentally. He called Olivia effing stupid.
Yeah,
I don't tell my kids that.
Yes,
For
you
one,
do.
that's you assuming I do.
All right,
But
Ms.
then
Thompson, Ms. Thompson, just let her finish.
I also have a recording of him calling Olivia effing stupid, and that the court calls her effing stupid. I have that all in recording. Miss Hombridge listened to it, and I have like screenshots, and he sent me it about telling the kids that he wants to sign his rights over, to have me meet him down at the courthouse so I can sign away his child support and his rights. He
Because
sent
you
that
guys
to
make
both
false
children.
allegations.
Hold on, Mr. Hobson. We're going to mute you, Mr. Hobson. If Mr. Gorski, what's all about? If he wants to sign for rights, why don't they do that this afternoon?
Judge,
That's what this isn't the first time that he sent these to the kids either. Months ago, he sent it to the kids and myself. He also sent our youngest daughter, Haley, a screenshot of him going back and forth on Facebook to somebody calling him a crackhead, and saying that he sells crack. And I have that. I wasn't able to submit it because of the holidays, but I do have that I got off of her phone.
Are your daughters in counseling?
Yes, they are. They've been in counseling.
Okay. Ms. Gorski, are you aware of the counseling?
Yeah, Judge, I think they do something on Zoom. They're counselors in Grand Rapids. I've asked before to have something more local so that the parents can participate and it can be meaningful. Ms. Calhoun thinks that this Grand Rapids person is effective. I don't know whether that's true or not.
Matt did agree to them continuing seeing this counselor, so I don't know why that's getting brought up again, because they're doing fine in it. And Matt had the information to contact the counselor, and he never did.
It's being brought up because
the
question.
They should be in counseling. It sounds like they've got a lot going on in their lives, and they acrimony between their parents, which adversely affects them. These children need to be in counseling. How often do they see the counselor? Once a month?
No, more than that. It depends on, well, they go the 9th of this month because of the holidays. They went right before Christmas. They did it. It's usually, we try every week, but it's every other week recently.
Well, the courts have not heard any allegations that that dad or his conduct is abusive to the children, or that it adversely affects their emotional or psychological well-being, Mr. Calhoun. So the court will, in fact, adopt this recommendation, reinstate dad's parenting time, and grant him to make up parenting time that's being recommended. Again, you can't, you got to wait for a court order to suspend parenting time. You just can't unilaterally decide to do that. If in fact there's some issues, you have to contact law enforcement or CPS. Again, if in fact the children are disclosing things to this therapist, you have that therapist put something in writing and submit that to the friendly court.
Well, there's also the temporary reserve that Ms. Hombridge put in there, so that's what I went by as well.
Right, we're setting that aside. That's a recommended order. She's not a judge.
Yeah.
It's a recommended order.
I understand.
Mr. Hobson has objected to that. That's what's before the court. So the court will specifically set aside and cancel that referee recommended order of December 6, 2023. And with that, let's try to move forward. I know, Ms. Gorski, you're asking for a finding of contempt. Wasn't there a prior finding of contempt?
Yes, there was, Judge.
Okay.
And my client waived any makeup parenting time in an effort to move forward and to act as an act of goodwill to try to co-parent with Ms. Calhoun. And this is where we are today. I would note that last year he missed Easter, he missed his girls' birthdays, and he missed Christmas. And these, you know, Haley, the younger one, has called him crying. Ms. Calhoun does not foster and facilitate their relationship. If she thought there was a concern about Mr. Hobson and his conduct, the thing to do is to pick up the phone and call him and say, the girls just said the craziest thing. What's going on? And give him the opportunity to respond. But instead, she makes these crazy allegations and goes running to law enforcement. And tellingly, these children have been in counseling, and those counselors, or the counselor, is a mandatory reporter. There has been no report made that these children have disclosed any abuse.
Right. All right, so what the court will reserve your request for finding contempt at this time, Ms. Gorski. So at least that's what we note that in the record, Ms. Sanders. We can just simply modify that last sentence, that the court recognizes that defense requesting finding contempt, and attorney fees court will reserve finding contempt at this point in time. So Ms. Calhoun, hopefully we're not going to be back for report on the allegation of this nature. And Ms. Gorski is correct. If in fact these children were being abused and neglected, the counselor has a duty to contact appropriate officials.
Correct. And as well that she contacted me after, so their counselor contacted me about this when Olivia reported it to her. And she stated to me that she contacted CPS. I don't know. We've never got any contact from CPS. So that's all I have on that one.
Did you ask her who she spoke with at CPS?
She said she did speak with somebody on the phone. I did not ask who she spoke with.
That's what you should do next time. All right, event. All right, let's try to move forward. Ms. Calhoun and Mr. Hobson move forward and reinstate this in the relationship between dad and the daughters. So it requires an effort on both parts. So again, dad's spending time. What time will dad pick up the girls today?
Oh, I think it's 6. I think he said 6 o'clock. 6 o'clock.
Trying to recall the past parenting time order. Is that correct? 6 o'clock, Ms. Calhoun?
I think it is 6 o'clock. I'm not, is it 6 or is it 5? I'm not exactly sure.
Wednesdays overnight and every other weekend, correct?
Yes.
Wednesday at 5 o'clock.
Yes.
To Thursday to school at 9 o'clock, no school. So it's from 5 o'clock. It's in 2 hours. Dad will pick up and drop off, correct? He can provide all transportation.
Yes.
All right, so 5 o'clock till 9 o'clock tomorrow morning is dad. Then every other weekend. That every other weekend will start this weekend, January 5. And that is Friday at 5 until back to school on Monday morning or 9 o'clock if no school. All right, let's get back on track as dad's parenting time is previously ordered back on October 11th, 2023. All right, that will conclude the show. You can all zoom out for the court.
Thank you.
Troy Laylor's motion terminated personal protection order entered on October 30th, 2023. This hearing is being conducted via Zoom. It occurs that Troy Laydler is present and ma'am, you're Callie Edmondson. Is that correct?
Yes.
Okay. We have the child in common. Is that correct?
Yes.
Okay. I don't know how you handle parenting time. Mr. Laydler, in your motion to terminate.
His family come and gets the kids.
I'm sorry, what'd you say?
His family comes and gets the kids.
Okay, so that worked out. Mr. Laydler, in your motion to terminate, you simply allege that Miss Edmondson continues to contact you and that she's harassing you. So maybe you need to file a PPO against her if she's threatening you with physical harm or violence. But hold on, ma'am, hold on. You just can't speak out. However, the allegations, you do not deny these allegations, Mr. Laydler. It's alleged on August 15, 2023 that you grabbed her, she's coming out of the shower, you grabbed her, threw her outside. You basically touched without her permission. And then you tried to choke her. So there's more. You do not deny that in your motion, Mr. Laydler. So the court's inclined to deny your motion terminate.
Okay.
You understand? You don't deny these allegations. You simply say she's contacted you. And Ms. Edmondson, if you're concerned about your well-being, why are you contacting Mr. Laydler? I mean, you shouldn't be. If you're fearful of your personal safety, you should not be contacting him. Both of you keep your separate lives and have family to do pick-ups and drop-offs, right?
Yes.
Yes, sir.
this PPO will expire automatically on October 30th of 2024, Mr. Laidler. It just prohibits you from us, just don't enter the home at don't threaten or
He has
assault Miss Edmondson or interfere with her employment. That's it.
Okay.
You can talk to each other, but only as it relates to the children. So again, the court is inclined to deny Mr. Laidler's motion for the reason he does not deny the allegations. Do you have any other questions, Mr. Laidler?
No, sir.
Ms. Edmondson, do you have any other questions?
Sir, yes, I want to apply something.
What's your question, ma'am?
I don't have a question. I want to imply something.
Well, I just want to know if you have any questions. If you don't have any questions, I will conclude this hearing. PPO will continue. And again, if you're fearful of your well-being, don't be bothered, Mr. Laidler. Unless it relates to the children. Unless you need to communicate about children. You got a sick child? Yeah, let them know about the text about a sick child. But otherwise, don't be reaching them contact 6 times a day.
I'm not.
Okay. All right. All right. Good luck to both. You can both zoom out.
Yes, sir.
Both mailed a copy of this order.